I'd like to welcome you all here to our third distinguished visitor talk for this academic year and certainly for this semester. I want to welcome you all here and just to give a brief introduction before I introduce our speaker. Drones, artificial intelligence, robotics, they're all part of a new landscape that we're seeing in terms of technology, and intersecting with that is how it connects with the law. It intersects in many ways: property, torts, privacy, criminal law. You could use, I have many of my criminal law students here. In terms of harassment, it also relates to international law when we're talking about more and more these days the use of drone warfare to execute certain military operations. So it's going to be part of our new legal landscape, and so it's with that in mind that I'm very delighted that we have someone who's who's an emerging established scholar, and emerging in this very area here to speak to us on a very specific area dealing with this type of new technology. Professor Kristin Thomasen. She joined the Faculty of Law at the University of Windsor earlier this year in January 2017 as an assistant professor. Her area of focus is really the intersection between law, robotics, and society. And her research, of course, looks at the legal, social, and ethical implications of robot technologies and artificial intelligence. She's currently completing her Ph.D. with the University of Ottawa's Faculty of Law, the Common Law section. Her thesis explores the implications of drone technology for privacy in public spaces in Canada, as it turns out, what we're going to listen to today. Prior to starting her Ph.D., Professor Thomasen clerked for Madam Justice Abella at the Supreme Court of Canada in 2013-14. She also clerked prior to that at the Alberta Court of Queen's Bench, and articled with Alberta Justice before that. So she's very accomplished, as you can see, in addition to her expertise in artificial intelligence. And she's also a member of the Law Society of Alberta. So I'm looking very forward, and I'm sure you all are too, to listen to her speak on this very cutting edge area. So please join me in welcoming Professor Thomasen.
Thank you. Thank you very much. Thank you all so much for having me here. I'm really excited to speak to you about some of the research that I'm working on right now. And thank you so much for the kind introduction. I really appreciate that. So, like I said, some aspects of what I'm going to be presenting on are actually research that I'm working on at the moment. And so I'm really excited to hear your feedback, your thoughts, your comments at the end of the presentation in our Q&A. And I'm happy to talk, all things law and robotics related also at that time, if you have questions beyond sort of what comes up in the presentation. So on the high level, what I'm going to talk about today for the next roughly 40 minutes, because I definitely want to save time for some Q&A at the end, I'm going to explain why I think we need to be concerned about the privacy issues that arise from personal drone use, so hence the title. And then I'm going to talk towards the end of the presentation about some of the ways in which I think we can start to resolve those privacy issues. So just to start us off, this is the kind of drone I'm talking about. So I'm talking about, when I say personal drone use, sometimes they're referred to as recreational drones. Really, that terminology comes from the person using it and why they're using it. So we're talking about not commercial uses, not using this for profit, not using it for research, just using it kind of for fun or for whatever activities I feel like using my drone for beyond those specific commercial aspects. Talking about relatively small size. Here you can see the obvious feature being the camera sticking out of the bottom, relatively accessible. I'll talk a little bit more specifically about some of the accessibility aspects of personal drones and why I think that's relevant to privacy as I move through the presentation, but just to get sort of a starting idea on what we're talking about today. Okay, so I'd like you to just take a moment and imagine yourself in your backyard. And imagine you look up in the sky and you see a drone like the one I just showed you sort of hovering over the backyard space. It's hovering there, maybe it's moving around a little bit. It's got that camera that I showed you affixed to the bottom. Perhaps it feels a little bit like an eye. There's a little bit of anthropomorphization, as in like humanizing of the technology. And then it flies away. What are you feeling? I know, at least for me, one of the things I'd be thinking is, who's flying this drone? What purpose? What information is it collecting? Why is it here? What's going on? This is a story that we see coming up more and more frequently, anecdotally and in media stories, in terms of the ways in which individuals are engaging with drone technology. Not the users of drones, but individuals, third party, unrelated to the drone. Now take that exact same story and imagine yourself out on a beach or in a public park. The same kind of sentiment or reaction might emerge, that visceral feeling of why is this happening, who's flying this drone, what's going on. But interestingly, we can see in some of the very few legal cases that have dealt with drones and privacy in North America, that there's an important distinction here. And I've hinted at it in my title. But essentially, I'm going to talk to you about two legal cases that arose in the United States over the last few years dealing with drones and privacy to emphasize what I think is going to be one of the most important points when it comes to drone technology and privacy. So the first is this gentleman. The name goes by the moniker of the Drone Slayer. That's a self-proclaimed moniker. His name is William Meredith. So a few years ago, he walks out into his backyard and part of the sensational aspects of this story is his two young daughters are playing in the backyard, and a drone flies over the backyard and is hovering around. Now, this particular situation happened to take place in Kentucky, and that's important because of certain legal protections for privacy of your property, of your private space. So he sees this drone hovering, he goes into his house, he grabs his gun, as you can see featured in his picture, and he comes back outside and he shoots down the drone. Incredibly unsafe. He's in a residential area. This is a terrible idea. Not recommended.
So that makes sense.
Well, what's relevant about it being in Kentucky is that Kentucky has a law that permits you to shoot, to take any action necessary to protect your privacy, including, up to and including shooting at a drone, for example. So before the court sort of resolved this issue, he's charged with wanton endangerment, because obviously it's very dangerous to shoot a drone over residential space. And he goes to court and he makes a privacy claim. And he says, I was protecting my privacy. And the court ultimately upheld that. And that's since gone on to be challenged in different ways from different aspects. And the court has continued to uphold this idea that because the drone was over his backyard, it was within the tree line of his property, he was fully entitled to protect his privacy in that case. So another example, another case involving drone privacy issues that actually went to court is, again, in the way that I juxtapose those two examples from the beginning, here we have a situation of a woman who's at the beach. She's lying on the beach enjoying some time with her friends, and she sees a drone flying overhead and has the same kind of visceral reaction. So in the anecdotal explanation from the individuals involved in these cases, we see a very similar story. She identifies the drone operator and confronts him, and ultimately it leads to an altercation. And she is tried with assault. So she's charged with assault, goes to court. She actually ends up going to prison for assault in that case. And the drone operator was essentially told by the police involved in the situation, you're totally permitted to be here. This is lawful. There's no privacy in this public place because it's a public beach. Just maybe next time exercise a little more caution in terms of the social norms that you're violating. But legally, he was doing nothing wrong. And of course, assault is not the solution to this, but it exemplifies some of the visceral response that people have to this feeling of invasiveness that can arise from some of these unique features associated with the drone. And so I think that the one distinction between these stories and the key distinction that arises when we're talking about some of the privacy problems that are coming up with personal drone use is this location-based analysis of your interest in privacy. So for the remainder of this conversation, for the talk today, I really want to talk to you. This is me from my personal drone. I really want to talk to you about, as a motivator for the importance of this talk, about the ways in which robotic technologies, and I think drones are a prime example, but the ways in which robotic technologies are really changing the experience of public spaces, and why I think that's really important to how we think about privacy in this country and how our privacy laws evolve in Canada in response to some of this roboticization of public spaces. And drones are by no means the only technology, but I think that they're the most accessible at this time in terms of robotic or robotic-like technologies. You can go on Amazon, you can purchase a drone, and you can operate it relatively straightforwardly in Canada. But we also see autonomous vehicles. We also see other sort of public space technologies emerging. So I think this will be the first to sort of set the stage for how the legal response is going to evolve in public spaces. Okay, so I study the drone because of that reason, because I think it's really interesting to see sort of on the cutting edge of where we're going. But I'm interested in personal drones in particular. So distinguishing this from sort of corporate drone use, or even you can think of like a real estate agent using a drone to get cool footage of a house to use for sale. That would fall within sort of this commercial drone. I'm interested in personal drones because of three key features. They're commercially accessible, they're fairly unregulated, and interpersonal privacy. So when we're thinking about different privacy regimes in Canada, interpersonal, as between you and I as private individuals, is really undeveloped at this point, underdeveloped at this point, compared to other areas of privacy law. So I think that makes it a really important conversation given this changing nature of data collection and surveillance. So when I talk about commercial accessibility, I've alluded to this already. Here's just the top clip from Amazon when I search drone. So drones are relatively accessible in the sense that for the price of a good cell phone, you can also get a pretty good drone. They're limited in certain ways, in particular battery life. So the drone that I have is a Spark. It stays in the sky for 10 minutes, so I can get some pretty cool footage, but by no means am I like following somebody around for an entire day with that drone. But that's one aspect of the technology that's really changing, and I think once it gets to a point where battery life can actually sustain much longer flights, these issues that I'm going to raise today are going to become incredibly significant, and the courts, if they haven't already, are going to be forced to deal with them. But another aspect of drones, which alludes back to sort of the intersection with artificial intelligence as well, is that the underlying programming is becoming incredibly sophisticated. So it used to be, I don't know if anybody in the room has ever flown sort of a model aircraft or like what we called a drone even just 5 years ago. It was really complicated. Like the remote control would have multiple functions. You'd have to be paying attention without going into all the terminology, but like, am I keeping it flat, sort of, am I keeping the wings flat? Is it going forward or back? Is it rolling too much? Do I want it to move forward? Do I want it to move up? Do I want it to move to the left or right? There were a lot of things that you had to be thinking about at the same time, and it was a little complicated to do. It was a skill. You had to practice. Now you can get drones on the internet which have software programming that's intelligent. It collects information through sensors and processes that information to allow the drone itself, the software within the drone, to control many of those functions. To the point that I could pull out my cell phone and I could say, I want my drone to fly over there, and just swipe my phone and it will go where I want it. There's still some skill involved. I've crashed my drone a couple of times. But it's becoming increasingly easy, and that makes it increasingly accessible to anybody who might be interested in using the technology. Now, I just want to show a really quick clip, and I hope that I can do this seamlessly and not ruin the presentation. But one aspect about drones that I think is really important, though, when we're thinking about privacy is just how loud they are. And I'm just going to play this for 2 seconds. So the motor is incredibly loud. This is not exactly a discrete technology. So when we're talking about privacy concerns, I'm actually, when we're thinking about personal use drones, I'm much less concerned with that sort of discrete and, sorry, I can't think and talk at the same time. I'm much less concerned with that sort of like discrete, secret surveillance as I am with surveillance that is happening, but you feel maybe you have no recourse for. Okay, so then and also I just wanted to point out that this is an inherently public space technology, both in the sense that the space in which drones can fly is airspace, which has been legally designated as a public space, and I'm happy to talk more about the history of that in the Q&A. I don't want to go into too many details just for interest of time, but airspace at some point above your private property and definitely above all public spaces is legally designated public space. So when you're flying a drone, it's operating in a public space, but also it engages public spaces for the individuals on the ground, third parties who are seeing the technology in the sky, because it actually doesn't function very well indoors. So really we're looking at a technology that for its own technological capability might not be very usable inside, but also you lose a lot of the reasons why you might use drones, like cool photography, videography, imagery, surveillance, that sort of thing. Often it's really connected to outdoor spaces. So we are really talking about something that particularly challenges the public. But the drone itself, in terms of drone-specific rules in Canada, is fairly loosely regulated. So up until quite recently, personal use drones were pretty much unregulated as long as you didn't fly them in front of a plane. More recently, Transport Canada, which is the regulator of airspace, of all things airspace, and that's been interpreted to include drones, Transport Canada has adopted a series of rules, and I don't actually expect you to be able to read all of those. I know they're quite small, but essentially it's this list of rules that they have up on their website that now apply to recreational drone users. So people, the individuals that I'm talking about using drones. And what these do is essentially try to set out safety restrictions. So trying to avoid airspace safety concerns like drones flying into planes. These really came about in response to a pretty high, a pretty sensational sort of media covered situation, where a drone almost collided with a plane. A drone has since collided with a plane in Canada. Transport Canada is very much concerned about that. So that's really what these rules are guided towards. And one thing that they do include is staying 30 meters away from other people, like third parties not involved in your drone operation. So that can have some privacy effect, but really it's only there for safety. Like, we just don't want these drones falling on somebody's head. You know, Transport Canada is worried about the media and legal implications of that. And so as the technology becomes safer and as regulators become more comfortable with the safety, I think that what maybe, you know, a sort of implied privacy protection might have existed in those safety rules, it stands to change. And just as a heads up, Transport Canada is looking at amending their rules. This has been a discussion for a couple of years now. It looks like it's getting closer. They recently had a public commentary to which I submitted comments, encouraging them to think about privacy. I don't know that that will be picked up upon, but essentially, again, the proposed rules are a more nuanced version of the same kind of safety idea. So really concerned with drones falling on people, drones running into airplanes. How can we protect against these issues or try to avoid them to the best extent possible? So when it comes to privacy, Transport Canada has very much had a hands-off position and has refused to address privacy issues. And also, you know, just generally speaking, there aren't any rules that particularly regulate it. So why are drones so creepy? What are the privacy concerns that we're really talking about when we talk about drone technology? And this is coming from somebody who is a drone user herself, and I think the technology has an amazing range of beneficial uses and applications, but there are a number of features of the technology that really do engage privacy. And I have boiled those down, I think, to transparency and accountability issues, that the technology and the way in which it operates undermine transparency and accountability that we ordinarily could expect in an interpersonal relationship, whether it's with a stranger or whether it's with somebody you know. So there's an information imbalance, and that comes from, in those examples that I gave at the beginning of the presentation, this idea of, I don't know who's flying the drone necessarily, it might not be immediately obvious. It might not be obvious to me immediately whether it's collecting information, what kind of information it's collecting, for what purpose. And I might not necessarily have sort of an immediate mechanism or instinctive reaction in terms of how I can deal with that. And that's disempowering, I think, in these interpersonal encounters. It's also embodied. This is a term that comes up in relation to robotics and the legal implications of robotics on a lot. And this is the idea that robotic technologies, drones included, are a physical entity. So rely on and operate through software programming, but in a physical way. So one of the big legal concerns with that is obviously, like, a robot could roll over your foot or a drone could fall on you, and this could inspire some kind of legal recourse for physical harm. But embodiment also has important implications for privacy when we think about some physical entity that can invade my personal space. So it feels invasive. And then there's anthropomorphism. So this is the natural human tendency to treat things that have human-like qualities as though they're lifelike. And I think that really comes up with the drone in terms of, like, this idea of a camera fixed to the bottom, kind of looks like an eye, it's looking at you, it's watching you. There are some panoptic feelings that can come from drone technology. And that can lead us to these self-defense measures. So really my theory with drones and why they feel so creepy in a lot of these anecdotal stories especially is that they undermine or sever the social relationship that we have with strangers when we're in public spaces. Because they undermine context, they undermine trust, and they undermine our feeling of recourse. And part of that stems from the fact that legal recourse when it comes to privacy is fairly minimal in public spaces. And so, like I said, I'm in the process of working through some thinking in these areas, and so I'm not at the point where I feel quite comfortable to speak to you today about Quebec's various interpersonal privacy protections, because it's a different legal regime, and I'm still trying to get up to tune on that, and also Indigenous legal traditions in response to interpersonal privacy. But in the common law provinces, what we really see coming up through the courts in terms of recourse, what rights do I have in terms of protecting my privacy vis-a-vis individuals, other private individual strangers, or people I might know? The primary source of recourse would be tort law. And so in Canada, tort law is treated differently across the country. Depending on which province you're in, you may or may not have different protections. We have 4 statutes that create a statutory tort of invasion of privacy, in Manitoba being one of them, BC, Saskatchewan, and Newfoundland. And then we have a developing common law tort, which has sort of emerged and been recognized in Ontario in a case called Jones, but there's no reason to believe that another court of appeal won't recognize that as well in the provinces and territories, other than the fact that it just hasn't come up there yet. And so I just want to sort of touch on, I think, what are some important aspects of these legal recourses that are challenged by drones, or that are particularly challenging when we think about drone privacy. So starting with the provincial torts, the 4 provincial torts across the board are all actionable without any proof of damages or harm. So you don't have to prove that you were harmed by the fact that you maybe felt some invasiveness when you're out on the beach. Let's say somebody's captured video of you that you feel really uncomfortable with. You don't have to prove that there was losses stemming from that. You do have to prove that it was a willful invasion of your privacy. So the person operating the drone intended to engage your privacy interests. But what I think gets really interesting, and why this is an interesting area to look at, is that none of the 4 provincial torts actually define what privacy is. They don't tell the courts how to interpret the statute in terms of an understanding of what do we mean by privacy here as the legislature. In 3 of the 4 provinces with the statutes, so Manitoba excluded, basically what the court says, what the act says, is that the nature and degree of privacy to which a person's entitled is based on what's reasonable in the circumstances. And that becomes really important, because when we're thinking about, like, okay, privacy is whatever's reasonable in the circumstances, what are the relevant circumstances, and how does that apply when we're in public space? And it turns out that that's been incredibly significant. And just before I move into that, I'll just touch on a couple of other things about these statutes. So the difference with Manitoba is that the circumstances actually only comes up at the phase of considering damages, which is really interesting. Like, I think in Manitoba, you can make an argument that there is a much broader potential for the interpretation of privacy under the statute. The challenge being there's almost no case law. So in all 4 of these contexts, there's very little case law. BC has by far the most of the 4 provinces, but even that is fairly sporadic. One thing that's interesting to also note in regard to the 4 statutory torts, at least, is that just recently, in this case that I've got mentioned on the slides, Duez and Facebook, the Supreme Court of Canada said or acknowledged that privacy statutes in Canada, which create a private law cause of action between 2 individuals, have a quasi-constitutional status. What exactly does that mean? It's not entirely clear. The court has used that term, quasi-constitutional status, on a number of occasions, and hasn't exactly given us, as legal academics, as law students, as lawyers, hasn't really given clear explanation of what exactly that means. But generally speaking, it seems to suggest that that a quasi-constitutional right or cause of action is deserving of a broad and generous interpretation in accordance with sort of charter principles, constitutional principles. So obviously hearkening to Section 8 of the Charter, which protects a reasonable expectation of privacy. Okay, so I mentioned, that circumstances, what's reasonable in the circumstances is really important. And that has come out in the privacy statutes, at least where it's been interpreted. And this is just one example of where the court has made maybe the most poignant or the most explicit statement of what location means to assessing whether or not somebody expects privacy. And this is from a 2005 case in BC, where basically the court says, if you're in public space, that's determinative of your reasonable expectation of privacy. That one circumstance, in terms of the location, will determine whether or not you could reasonably expect privacy to the extent that it could be protected by tort. Now, this is, like I said, it's a 2005 case. There have been some other cases decided since then that have maybe nuanced this a little bit, so it's maybe not quite so strong. And this case hasn't received a lot of treatment since then. But at the same time, it hasn't been overturned, or the court hasn't really come back to give it a negative treatment either. So really what we see sort of coming up in a lot of the cases is this idea that location is a key circumstance. And I mentioned Ontario has this evolving common law tort of invasion of privacy as well. And again, in the Ontario treatment, kind of picked up directly from the American tort of invasion of privacy, is this idea that seclusion is the interest. So my interest in privacy is that you can't invade something that I have kept secluded or secret or private in that sense. And so these cases, these decisions by the courts all come down to sort of one theme of what is our theory of privacy in Canada when we're talking about public space. And that's a secrecy theory of privacy. So privacy is very difficult to define. It's very hard to put your finger on what exactly is a definition of privacy. And the Supreme Court has pointed that out time and time again, going so far as to say privacy is a protean concept. It evolves, it changes. We don't necessarily know exactly how to define it. But what we really see coming out of a lot of academic thinking about privacy and different cases on privacy are these different theories of how to approach an understanding of what privacy is. And sort of woven throughout all of the tort jurisprudence is this idea of a secrecy theory of privacy, which means that something is private when I have managed to keep it secret, or something is private when I've kept it secluded or within the home or concealed from public view. And that's why we see that there's such a challenge in terms of identifying legal recourse when we're out in public space under this theory, because the theory requires secrecy, and you can't possibly have secrecy when you're in public, is sort of the reasoning. One additional, so in the introduction we talked about how this touches drone law, robotic technologies touch on a number of different areas of law, both public and private. So when we're thinking about interpersonal protections and recourse, there's also, of course, the criminal code. And a key criminal code protection in terms of interpersonal privacy invasions is the voyeurism section of the criminal code, which essentially says, or prohibits, makes it an offense to secretly video record somebody in a context where they have a reasonable expectation of privacy. So the Ontario Court of Appeal very recently, in a case called Jarvis, was just put in the position of interpreting this provision in the context of a teacher at a high school who was secretly filming his female students. So, the ultimate discussion of sort of disempowerment, of abuse of a power relationship. But the court really, in a context of sort of a statutory interpretation approach to what does this criminal code offense actually prevent, comes back to this idea again of when you're in a public place, you've exposed yourself, and therefore there is no privacy. Okay, so I think that this secrecy theory of privacy is going to become a huge problem with drone technology, going back to sort of at the beginning of the presentation, with drone technology, with public space technologies that absorb information, that invade physical space, and we're going to see these challenges arising more and more often. I've recently done some work, and I'd be happy to touch on it in Q&A if anyone's interested, on sort of the gender dynamic of privacy invasions in public space. In this presentation, speaking just more generally about the fact that there's a lack of legal recourse. So what can we do moving forward? I think one aspect is going to mean moving beyond airspace safety. So thinking beyond just how do we keep airspace safe? How do we ensure drones don't fall on people's heads? Because individuals engaged in a privacy invasive situation with a stranger, with somebody they can't even identify, maybe the drone falling on them is not their number one concern. In particular, when you think about examples of harassment or stalking or those kinds of very invasive uses of technology, which are made possible, even more possible by drones, which sort of eliminate the friction points to some of these invasive actions in public space. So moving beyond airspace safety can include Transport Canada dealing with some of those issues that I mentioned at the beginning that are what make drones so creepy. Information imbalance. How do we communicate more information from the drone to an individual engaging with that drone? when they're out, in trying to enjoy themselves in public. Some suggestions have included things like different lights, different colors of lights that need to be actually regulating the design so that you have a different light color on top of the drone, whether it's recording, whether it's not recording, at least giving some information. Things like emblazoning it with name and information has been another suggestion, something that Transport Canada is looking at right now. I think when we're talking about interpersonal issues, we also have to think about the privacy interests of the individual operating the drone, and so there needs to be some balancing there. And I actually have some concern with the idea of putting somebody's name and address right on the drone, where you're dealing with some situations that have led to conflict and interpersonal violence even. And so those are things to think about. But essentially, Transport Canada could even move beyond safety and take a broader idea of safety in terms of safety of the individuals engaging with drones and how comfortable they feel in the context of seeing the technology. But more interestingly to me is to look at this technology, think about how it challenges privacy, and then think about how can we change the technology neutral laws. And by that I mean, how can we deal with how we conceptualize privacy in this country to better respond to increasing invasiveness, increasing invasions in public spaces. And so, throughout talking about this secrecy theory of privacy, I was emphasizing how a lot of this comes down to an idea of what's reasonable in the circumstances. What can I reasonably expect in the circumstances of an encounter in guiding whether or not I'm entitled to privacy? And I think, the courts, as I said, haven't really spent a lot of time interpreting and theorizing on the torts of the statutory and common law